go. So now we're recording. So, want to bring Justin on. Hopefully this webinar tonight will serve as evidence. Justin is an actual real life attorney. He does this for a living, which is amazing, because I always hear, there's nobody that does that. There's no reason for somebody to specialize in legal things for dentists. There's not enough demand. And here is somebody who actually does it. And like I said, hopefully this video will become a resource for people to refer back to, as much as I hate to say it, to prove your point when you need to get it from, not just because Rick said so, but because now here's an actual attorney who spends his life helping dentists actually saying it. And if anybody's familiar with the law, I'm going to assume it's going to be him. So with that said, Justin, again, I want to thank you for being here with us tonight. Thank you for taking the time. I know it's evening. It's hard to get away from family, but I certainly appreciate you being here. And wanted to just give you a minute to tell everybody a little about yourself, about what you guys do, where you practice, because I think that's important for people to understand who you are, so that you can become that kind of trusted resource to really back me up, but to offer advice that will be hopefully listened to.
Well, Rick, first of all, thank you for the opportunity. Whenever I have a chance to speak with a colleague about, what I enjoy, which strangely enough is helping dentists, representing dentists, talking about how dentists can protect their license and their livelihood. I always take myself up and take the opportunity to do so. So yes, I am a real life practicing lawyer. I'm a partner at the law firm of Flannery, Georgalis. I'm based in our firm's Cleveland office. We also have offices in Columbus, Detroit, Pittsburgh, and Charlotte. But I've really managed to build a nationwide practice of representing dentists and dental professionals. So our firm as a whole tends to focus on representing individuals and entities that are under some sort of regulatory enforcement. So some government actor is looking at that individual or entity for potentially wrongdoing. And so we, using our government background experience, most of our partners are former federal prosecutors. We employ former federal agents that serve as our firm's investigators, including 2 former HHS OIG investigators. And we help to represent those individuals and entities under investigation. Now, when it gets into the dental arena, there's really a few different types of matters that myself and my colleagues handle. It can be a board investigation, so a licensee is under investigation by the state dental board in which they practice. It can be a state or federal criminal investigation, generally relating to allegations of improper billing, or it can be insurance audits. And sometimes you'll find that the 3 of those can all go together. I've found in the 10 plus years that I've been working and representing dentists in those types of matters that there's really a misconception as to what an audit can mean. Sometimes an audit is just a necessary evil and a part of the insurance process. Insurance companies like to conduct audits to make sure that the providers within their network are complying with the terms of their provider agreement, complying with the terms of the contract that they signed. Other times, audits are because from the insurance company's perspective, there are warning bells that have gone off. Either there's been some sort of report made to the insurance company, or what is happening more frequently these days, the particular provider or the practice is a statistical outlier, meaning that for a particular service or based in comparison to other providers in the area, the data analytics suggests that that practice and that provider are different and abnormal than the other providers around them. And so that oftentimes can trigger an audit.
And I think everybody, or at least most people, because I get asked this all the time, oh, I just got a letter from United Concordia, and they're saying we do 7.39% more three surface fillings than the average dentist in our area. And, the vast majority of the time I tell them, listen, as long as you're not doing anything wrong, you're not inflating numbers, you're not, lopping off a cusp before you take a PA in order to make it look like a tooth needs a crown more than it really did, you don't really have anything to worry about. But people don't really understand how statistical insurance companies are. They don't understand those numbers that they deep dive into to know, you're doing 2.8% more two surface fillings than the average dentist, and that causes a red flag for them.
Exactly. In 2012, it's called the Healthcare Fraud Prevention Partnership was formed. And what that is, it's data and information sharing, not only between government entities, both at the local, state, and federal level, but it has grown to include private insurance companies as well. So they share data, they share information, and they analyze that information to determine if there's a certain practice, there's a certain provider that may necessitate some further review, may necessitate an audit. And data analytics isn't going anywhere. It's only going to become more and more prevalent as the sophistication in the analytics that these insurance companies and government agencies can do continues to improve.
Right. And really, I know recently one of the big things has become AI, and, insurance companies using AI to evaluate claims. We've seen some doozy rejected EOBs caused by that AI where, we submitted for a two surface posterior filling, and the denial code comes back, well, this isn't payable because there's no history of SRP. Okay, that's AI making a mistake and picking the wrong one. We get it fixed, make sure they reprocess and everything is good. But I think on the analytics side, it's gonna grow even more. Basically, I really think it's gonna get to the point where, an investigator, an auditor is gonna walk in the office in the morning and hit a button, and out's gonna print a list of 5 offices that they need to look at, because the computer told them you need to go look at these offices.
I totally agree. And that could already be happening for all we know.
Right.
I do want to go back to one thing. I'm a frequent reader of your Facebook group, and the questions that are posed and the comments both from yourself and from other members of the group. And I think that's actually how you and I got connected. Is I found myself repeatedly agreeing with your responses in certain situations. I'm not the expert that can tell a professional one code versus the other, but general questions of non-credentialed provider, treating provider, those types of things, those seem to be frequent questions amongst your group. Right. And I just constantly found myself reading them, seeing your answer, and just always shaking my head affirmatively. And so I was glad that you and I were able to connect, and certainly chatting here today. The one thing that I have found repeatedly through my representation of dentists, specifically in audits, is a lack of understanding and a lack of knowledge as to what are the terms of their provider agreement with a specific insurance company. It's a contract. And I think, in no other area of life would somebody sign a contract without taking the opportunity to read it and fully understand what they're obligating themselves to do under the terms of this contract. And it's not just dentists, it's medical professionals generally. You know, when they're getting credentialed with an insurance company, I don't always feel as if the appropriate homework is done on the front end to really understand what your obligations are, either from a documentation standpoint or from the insurance company's ability to walk into your office and make demands for charts and information. And I think if one takeaway that people could take from today's discussion is make sure that everyone has taken an opportunity to review what is required of them under their provider agreements. That's one easy thing that people can do. If you're looking for takeaways from tonight, that can be one of them, because I find frequently that that's not being done. And it's not for certain that it would avoid problems, but it can certainly put you closer to avoiding problems and further away from.
Right. And that's, you know, I've said that a lot because I know there's a lot of people out there who will say, oh, well, you know, the contract this and the contract that. I mean, we were talking last week and, you know, I said, answer the question now. Do you think if dentists actually took the time to read that whole contract, look at the provider manual, understand the requirements, the documentation, what they're agreeing to, do you think anybody in their right mind would ever sign one of those?
No.
I mean, it's crazy the demands that go on. And what I not love, but ironically love, is when a dentist says, but it's my office. I'll run it how I want to run it. And I said, but you signed this contract. That's not enforceable. It's too one-sided. You tell me, how good are insurance companies at enforcing those participation contracts?
Quite good. You know, once you put your signature on the agreement, you're obligated to abide by those terms. Are there circumstances potentially where you could argue that, you know, specific terms are one-sided and thus non-enforceable? That's probably the case. But when you are dealing with issues that fall within my skill set, you know, that's not going to be an argument that's going to win the day.
Right. And then
the fact of the matter is you need to know what you're signing your name to.
Right. And then you also have that little blurb, and you'll be much more familiar with this paragraph on a contract than I am. That little paragraph towards the end, usually the second or third one from the last, that says, if any one part of this contract is found unenforceable, the entire rest of the contract remains enforceable. I don't know what it's called, but
the severability provision. That's exactly right. Go. Yeah, they all have them. Right. It's a standard boilerplate provision. And so exactly what you said, just because one provision may be determined to be unenforceable, that doesn't make the totality of the agreement unenforceable.
Right. Now, here's a specific question for you, because we had a post in the group from like 4 years ago that actually lately, for some reason, has gotten some new traction. And I was reading through the old comments, the 4-year-old comments, and somebody said in there, you know, we're in a state that has a never, ever covered law that says if a service is never, ever covered, then the insurance company can't dictate the fee that the patient pays. That's only if it's a covered service they can dictate that. But many of the contracts have clauses in them that say, by signing this contract, you agree to waive your state law, and even for non-covered services, charge the patient the allowed fee instead of your full office fee. And 4 years ago, I had probably a 16 comment back and forth discussion with a dentist who said, that is illegal. It's illegal for them to put a clause in there asking you to violate state law. Can you kind of clear that up? Like, are they allowed to put a clause in there that says, we know your state says non-covered services, you can charge your full fee, but by signing here, you agree to waive that and only charge allowed fees, charge the network allowance.
Yeah, I think under that circumstance, the terms of the contract are going to carry the day. Again, if there's an acknowledgement and there's an agreement, that's really all that necessitates, being able to hold one party to abide by the terms of the contract. So, now I don't necessarily agree with whatever the comment was that it's illegal, but I certainly would feel comfortable advising that the terms of the agreed terms of the contract would rule the day.
Right. And that's another thing. And I don't know how into ERISA and federally and self-funded plans you get as far as that goes, but that's another thing people fail to recognize is, self-funded plans are exempt from state laws because they're overseen by the federal Department of Labor. So your state law doesn't apply to them, but it's non-covered, so I don't have to submit it. So now, one more question on contracts, just because I again, this is a very enlightening for me as well, because it like you said, it's the same questions over and over. I mean, probably in the group, 90% of the questions posted in the group, I could have an AI robot just copying and pasting from, a month ago, 4 months ago, 6 months ago, the same thing. And that's okay, because every time it gives me a chance to teach the new people. I mean, we're averaging, 300-400 new members every month in the group. So it helps to teach them as well. But here's the question, because I hear a lot of the time, our contract says we have to submit covered services to the insurance company, but we called and they said this one is non-covered. And I know you really want to look at the language, and I'm kind of paraphrasing here to give an exact answer, but there's one contract in particular that people point to, United Concordia's contract, where paragraph 4 says you agree to submit all covered services for our patients to the insurance company to be processed. Fine, that's covered services. In paragraph 6, it says the determination on what is a covered service shall be made on a claim by claim basis by United Concordia. To me, that's saying you're not going to know what's covered or not until you've submitted it. So
yeah,
I
agree. That's actually a little surprising to me, that it could be that vague to where, the insurance company is saying, we're going to make the decision on what's a covered service on essentially a case by case basis. So you submit everything. It would be my position, because you don't know what's covered versus not.
Yeah, and I'll send you some snips. It actually just came into my head, or I would have prepped you in advance with the language from those 2 paragraphs, because I know attorneys are big on language. But I would have prepped you with that so you could have seen exactly what it said. But it just boggles my mind, because people say all the time, you don't have to submit everything. You only have to submit it if it's a covered service. Great, I agree. Paragraph 4 says that.
Right.
But paragraph 6 says you have to submit covered services, and we determine what's a covered service, not you.
Wow.
So, that's always my kind of back and forth of just submit everything. Plus, those federal plans that are overseen by ERISA and the Federal Department of Labor, none of those rules really apply to them. You have to submit to them anyway, because they're exempt from your state law.
Right.
So, that causes a lot of confusion. But now, let me just go back to, we all know nobody would in their right mind would ever really sign a participation contract if they actually read it. They know people aren't going to read it. It is what it is. But I also understand the business side of it and the demographic side of it. Not every dentist in the country can be fee for service.
Right.
I'm in a town. I live in a little tiny town where the population is 5,200 and the average household income is, 38,900 and something dollars a year. Very few people in this town are able to walk into the dentist and drop $1,200 on a crown when they could go
Right.
to an in network and pay 320.
Right.
So I understand the back and forth there. So a lot of times it you have to, but kind of taking a step even further back and going back to, we had talked very briefly about audits. And this is something that I've been kind of saying really since COVID, that I have seen. I know I personally am getting more phone calls, text messages, Facebook messages from dentists saying, hey, I got this notice of audit. What do I have to do? Hey, and it's been kind of increasing since then. And I think there's a multitude of reasons that we won't get into right now because
We only have an hour.
we only have an hour and we're 23 minutes into it already. But what typically, because I hear all the time, oh, every dentist I know has gone their whole career. No dentist I know has ever been audited ever.
Right.
And I kind of wonder, because I see that number growing. Listen, there's 200,000 dentists in the country. No, I don't think every single one of them is going to get audited, but it's growing. I think that number is increasing for the AI and the analytics,
Sure.
all the numbers we talked about before. But really my question here, in a very roundabout way, is, typically, how do you respond, or how do you tell your clients to respond to that letter? Because I have seen people in some other Facebook groups say, oh, when I get those, I just throw them in the trash. I ignore them. They sent it certified. We signed for it, but no, never got to me. My front desk must have thrown it out. Whoops. How do you respond to that?
So I could, there are a couple cases that immediately come to mind where it wasn't as brazen as throwing it in the trash, but it certainly was. We received notice that we had been selected for an audit, and we either put it at the bottom of the stack or things got put on top of it. And we didn't take immediate action that really an audit requires. And I know the group is comprised of both dentists and dental staff. So I would encourage every office to have, it doesn't necessarily need to be in writing, although I think it helps as you bring new staff in and personnel change so they understand what the policies of the office are, to have a written policy as to what happens when we receive an audit or a letter from an insurance company or an agency that is serious. You can certainly, there's the run-of-the-mill correspondence, and then there's the correspondence where you receive it and the insurance company or the agency is demanding information from us. Those need to be moved to the top of the stack of importance, and need to be taken to either the practice owner or whoever the point person that is decided by the provider in the practice is going to be, so that they can immediately take the appropriate action. Sometimes these audits, require information in a very short period of time. And there's no way to bring greater scrutiny upon your practice than by throwing the initial letter in the trash or ignoring it and not complying with the timelines as identified in the letter. Now, it's always been my experience that if additional time is needed in order to compile the records that are being requested, they're generally going to give it to you. But what you need to do is you need to open up the lines of communication. There needs to be a communication between the office to whoever the signer on the letter is. It's not always the easiest to get in touch with that person that signed the letter, and sometimes there's not even a person identified on the letter, but there's always going to be a callback number that you can reach out to and have a conversation with someone and try to get more information. So whenever I'm brought into a situation involving insurance audit, the first thing I do is one, I let the insurance company know that I'm now representing the practice. So if there's any communications to be had, it's with me and it's not directly with the practice. And then two, I want to have a conversation. I want to know, why was the office selected for the audit? What in particular are you looking for? What is the scope of the audit? And that will help us to identify, is this more your run-of-the-mill audit where they're just reviewing records and your name was the unfortunate one that was selected? Or was your office selected because of some reason, whether it be data analytics, whether it be a patient complaint or a prior employee complaint, or some other reason that you have been selected? That's step one. Step two is, well, we need to look at the records ourselves. So if the insurance company is asking for 20 patients for specific services, or that were treated within a specific time range, we need to look at those services, we need to look at those records, and we need to be our own harshest critic. Is our document approach appropriate? Do we have x-rays if we've identified x-rays are taken? Are they diagnostic quality? Excuse me. Do we have signed consents? Are we doing everything that we need to be doing to, once those records are provided to the insurance company, they're going to pass the scrutiny of the insurance company. And more often than not, I totally understand that in the busy day of a dental practice, nobody's documentation is ever as perfect as they want it to be. If anybody had more time and had more time to write the note for a patient encounter more thoroughly, they would. It's just not the way the world works. But at the same time, that doesn't mean that your documentation can be so deficient that it's going to cause issues once received from the insurance company. Then we gotta provide the records, okay? And there's a way to provide records. I always like to make sure that records are provided as organized as an organized fashion as possible. Does it really give you any upper hand in terms of what the audit findings are going to be? Not really, but they expect to receive them in an organized fashion. And if you do provide them in an organized fashion, if the insurance company, and this is totally my opinion, so you could have a different opinion, if the insurance company is on the fence about making a particular determination, if you were respectful, if you were timely, if you provided things in an organized fashion, they're more inclined to give you a break than not.
I think
so
you want to make it
ahead.
look like you have your stuff together.
Exactly.
So they know you have your stuff together.
That's exactly right. That's exactly right. And even if you don't, that's the time to do it.
Right.
But too often I've seen in the past where, I'm brought in once an audit is underway and it's not going particularly well. And the provider or the practice owner, whoever, has said, well, we got it. And I just told my office manager to call the insurance company and just say, well, we'll reimburse them whatever amount of money they're looking for. And that's not going to work. Okay. When you receive the letter, it's not a drop everything type moment, but it's pretty close. Someone within that office, this now has to become their top priority, to make sure that we have all the information that the insurance company is looking for. It's provided to the doctor or doctors so that they can review it. You may also want to consider bringing in outside consultant to take a look at the records, just for a third-party review. And if that's not done, if the audit letters aren't taken seriously, then it could potentially make the situation worse. And that's where I said at the beginning where, an audit can sometimes start as just an audit and elevate to other things. Those are the types of situations that can happen. One particular instance that I can recall is I was engaged by a practice that went through an audit, and it took roughly 6 months for the insurance company to get the records that they had requested within 30 days of receipt of the notice. Finally, the records got there. They were reviewed. There were certainly scrutiny on the records and documentation and certain treatment decisions that were made that, from my position, may not have been made had they been more organized, more prompt, more professional in how they responded to the audit. And then after the audit was complete, the insurance company terminated their participation from the network. Once that was complete, because they're judge, jury, and executioner, they were then referred to the board for disciplinary action, both based on certain treatment of patients and then also based upon how they responded or their lack of appropriate response to the audit request. Excuse me.
I'm doing the same thing.
Yeah. Getting over strep throat from an 8-year-old. That's just how it goes these days. So anyway, there needs to be a plan in place, and then there needs to be compliance with that plan. So a point person notifies the doctors or the practice owner or both, however, whatever the structure of the office is. And then there should be a staff member whose primary responsibility is to compile the records that are requested. And then either the provider or the practice owner is reviewing those records before they're submitted, or you're having some outside consultant review those. In a perfect world, both, so that you know what's in those records before you submit them to the insurance company. That's always important. You don't want to just blindly collect the records and submit them without first having reviewed them and scrutinized them yourselves.
Right. Absolutely. Yeah. I mean, excuse me, you should definitely know. No, man, we're both coughing to death here.
I know. Contagious.
Mine's just starting. You're wrapping up. So
yes, I'm on amoxicillin. I'm at like halfway through it. So,
but there you go. You're good. But I'll be better for next week. But anyway, so I think that's a huge thing that people miss out on, is reviewing what they're sending in, making sure. I mean, listen, at that point, the chart notes are the chart notes. There's not editing of chart notes. There's not altering of them. You're not doing any of that because you can't do any of that. You can't,
well, you're exactly right. So the pushback I get is, well, what's it matter? Exactly what you said. It's not like I can change the chart notes now, but still, if you know that there's going to be an issue, it's always better to know what that issue is on the forefront, as opposed to having the insurance company come back and tell you, hey, we've reviewed all the records and we've got some serious concerns about X, Y, and Z.
Right. Yeah.
Because you can take proactive steps to remediate those issues, not by amending or altering, but we've already signed our staff up on, a refresher on proper documentation, or whatever the case may be. Right. There's always things you can do that, in the eyes of the insurance company, suggest that you're taking this seriously. You understand that there are things that you can do better, and you're taking the proper steps to do them better so that you don't find yourself in the same situation down the road.
Absolutely. It's always better to be proactive than reactive. I mean, I get phone calls from, different state boards. I mean, typically when I go in, I was in Texas, I don't know, a couple weeks ago. I can't even remember when, but was in Dallas speaking, And, one of the 2 days I spoke about, billing and coding and proper documentation and insurance and coordination and all that fun stuff. And 2 weeks after I got back, I got a phone call from somebody at the Texas State Dental Board saying, hey, we just want to confirm that these 2 doctors were in that class, because we've identified this class as one that meets our parameters for corrective
Sure.
guidance, and we just want to confirm.
What a compliment to you.
They sent us the CE certificate, but we just want to confirm they were actually there. And that's, by the way, if you come to one of my classes, don't sit in the back and read a newspaper, because I'll tell the board if they call me. That, I get that call, and, that's one of those things, is taking that. I'd rather be proactive. Proactive is always better than reactive 100% of the time. So it's just the way I think it should be. And I think we might have lost Justin.
Did you? Can you hear me, Rick?
I can hear you. I think your video up. Wait, you're moving now. There you go.
That's good.
We're back. And we're back.
Yes.
That brief commercial message.
Sorry about that.
But no, you're good.
I'm the only one in the office. You would think that the internet signal would be strong, but I guess not.
But where are you? What city are you in?
Well, I'm at the top of my building. I'm in Cleveland. How dare you?
There you go. There you go. But
so, Rick, not to play moderator here, but I see there's a couple questions, and I think
there are, and that's actually kind of the next thing I wanted to ask you about. And I think this is probably the big reason people are here, especially the office managers that are here, because this is a fight that happens daily in the group. And honestly, this is probably the thing that I get the most messages about from office managers saying, my dentist is asking me to do this. I don't feel comfortable with it. What should I do? And, I know you and I both commented on one post where, it was like, well, do you report? Do you not report? Do you call the insurance company? When you get a disgruntled ex-employee, it becomes that much easier for them to call the Delta Dental fraud line and say, this dentist is doing this, and this. And I think that's probably the easiest way to trigger an audit. But, so let's talk for a couple minutes here about fraud and what fraud actually is, because I see that term thrown around. And listen, I speak about fraud, but I think the word itself is used way too often. Well, they didn't submit a claim. Well, that's not really fraud. That's a contract violation, because the contract requires you. It's not specifically a fraudulent act. So, can you kind of just explain what, and I'm not asking for specific examples, but actually, like, what is fraud? What is the legal definition? I mean, you'll be able to tell that I watch those sovereign citizen videos on YouTube, but because I love smashing car windows. But what is the like Black's Law definition of fraud, of insurance fraud?
So it's really the intentional misrepresentation. So under the False Claims Act, it's the mens rea, or the mental state that one has to have is knowingly, but it's knowingly submitting some representation of fact that is false with the intent of deriving a benefit, or in this instance, a payment. That's fraud. When you submit something to an insurance company, that a claim that has false information on it, let's say who the treating provider was, that's fraud. And you're doing that because you're doing that with the intention of receiving a benefit, receiving a payment for that claim. So the question that has been popping up in your group a lot recently has been, well, we have a non
Well, I think we lost you again.
provider who just joined the practice. The owner tends to put Rick, are you
Uh-oh.
there?
We're here. We lost you there for a second. If you want to go,
I'm sorry.
no video, if that'll help your Cleveland internet, sorry, Ohioans, I apologize, but if that'll if that'll help you,
If it
please feel
happens
free.
again,
We lost pretty much all of that after
oh, okay, great.
the question that's popping up a
So
lot is, so we're talking about the provider, the treating provider on the claim form. And, like you said, the question that is popping up is, okay, we have a dentist come in, either a temporary dentist, they're here for covering for vacation, or they're here covering because our dentist had rotator cuff surgery or fell and broke her wrist while she was snowboarding or is on maternity leave, or we have an associate who we just got hired who isn't yet credentialed with the insurance companies. So we're submitting all of our claims with our owner doctor as the treating provider. Is that okay?
So the first couple, there are circumstances in which that is okay under a locum tenens agreement. There are pretty strict rules relating to that. And that's going to be insurance company by insurance company are going to have their own different rules that you need to look out for.
Right. But you need to have that locum
using
tenens agreement in advance, not
exactly,
just assume it's in place.
Exactly. And the one I think that most frequently occurs is maternity or paternity leave. Again, when you can plan for that in advance, you can have all the proper documentation in place. That is a situation in which it can be appropriate for the rendering provider to not be credentialed and it still be an appropriate claim. The latter example you provided, where we have a new associate joining the practice that's not credentialed, that is a false claim. There's just no other way to put it. If they aren't credentialed, but they're the ones rendering the service, it's not acceptable to put down the credentialed provider as their rendering provider. It may not get caught right away, but I have handled enough credentialing related audits and criminal investigations to know that at some point it will get caught, either because the data analytics will identify that, wow, there were a lot of claims being submitted by one particular provider on a particular day. I'm going to turn off my video. I apologize.
No, you're good.
Or it's weird, we had claims being submitted by the same rendering provider out of multiple offices on the same day. I mean, these are things that happen. This is information that government and insurance companies are able to identify, and this is going. And so trying to shoehorn a claim in from a non-credentialed provider, you may be successful in getting it paid, but that doesn't mean that you've gotten away with it. There will be scrutiny to come, and it could result in not just an audit, but in these situations when they can pretty easily prove that this was a non-credentialed provider, that will trigger criminal investigations. And with criminal investigations, now we're talking about the potential loss of liberty and not just the potential loss of dollars.
Right. And that's really the thing we all want to avoid. I mean, I know a lot of people who say, if you throw enough money at a problem, it'll go away. But I've seen a few cases where I think the attorney general or the prosecutor was like, this is where I'm gonna this is where I'm going to make my bones. And, we're going to send a message to all the dentists out there that this is the way it is. And they're, sometimes highly publicized. I mean, there was just one earlier in the year down in Florida where, I think 5 people were arrested for submitting the incorrect provider information because of a contracting delay, a credentialing delay. And, 5 people were arrested, $1.3 million in theft. And I just hear all the time, well, it won't happen to me. It'll never happen to me. And it won't until it does. I think that's my general point of view, is it won't happen to you until it does.
And it's a very, very slippery slope. You do it once, you do it twice, there's no immediate ramifications for doing it. You start to justify and rationalize continuing to do it. And it can very much have that snowball effect where you just don't have a credentialed provider, but you're billing them out under a credential provider's NPI number. And quickly that number grows into the hundreds of thousands of dollars. Well, now you've taken an isolated 1 or 2 claim issue and you've made it, felony level conduct that gets people put into prison for multiple years.
Right.
I just posted the other day when I can't remember what the exact question was, but I believe it was something relating to an office manager feeling uncomfortable with certain instructions that she was being given by the dentist practice owner. And just the other day, an office manager and dentist pled guilty in federal court in California. Now, they were engaged in some pretty clear fraudulent conduct, but if your dentist, your boss is telling you to do something that is improper, is illegal, you can't rely down the road. If ever it comes under question, it is not going to be a viable defense to say, well, my boss told me to do it.
Right.
You have to make your own decisions. And so if you know that something you're being instructed to do is not just improper, but illegal, you have to get out of there. And then you have to take the appropriate action to, as Rick, you indicated, to report them if you feel it's necessary. But yeah, there's no better, I'll just use the term whistleblower from an insurance standpoint or from a governmental standpoint than ex-spouses and ex-employees, because they know all the dirt and now they've got an axe to grind.
Right. Exactly. So, I mean, let me kind of hit some of these questions real quick. I mean, we didn't get to everything I had on my list I wanted to talk to, but I kind of knew that was going to happen. So, I know you and I had talked about this previously. I mean, before we go into answering these questions directly, but I am speaking, I think it's next weekend, the 20th and
Yes.
the 21st in Atlantic City, New Jersey. We're doing a Q&A with Andre Shirdan and myself and Teresa Duncan. I would love if you were able to come join us for that, sit on the Q&A panel on Saturday, talk, we could answer some more questions. I think it's going to be a great group of people. So, if you're able,
it'll be my pleasure. I'll be there. There.
Fantastic. That'll be wonderful, because I think adding the legal component on top of, Teresa and Andre and I saying, well, no, this is the way you do it and this is why you do it, but having that on there is a huge big bonus for everybody. So, with that said, that's great. So hopefully we can answer some more more questions, have some further discussion then next week when we're there.
Yes.
But we'll hit some of these questions real quick. First one, if I have a temp come in for a day, we are not allowed to list the owner doctor as the treating provider, correct? I'm going to say, you're probably not going to go through the locum tenens process
Right.
for a one day. So what do you say for that one day that a temp is in the office, that my dentist is having a splinter removed from his finger at the hospital? Can we bill the owner who's not in the office as the treating provider on those claim forms for that one day?
I would not bill it. I would not bill the treating provider to be the regular provider. I think you, as the question poses, you should bill that out as out of network.
Right. So you're billing that temporary doctor who's there for one day as the treating provider. They're the rendering provider. They're going to be treated as out of network because you don't have the locum tenens in advance. And yeah, they're going to be treated as out of network. That's just the way it is.
And I know that there are probably people on here that are saying it's one day, just do it. You're not going to get caught. That's probably true. You may not get caught the first time.
Until you piss off the wrong office manager or you upset the wrong front desk person.
But you're going to do it again because it was successful and you found it easy. And so you're going to do it again and again and again. It gets back to that snowball effect. Right. So just because it was easy doesn't mean it was right. So bill out of network. It's not that big of a deal. If we're talking about one day, it's always better to just do the right thing.
Exactly. So next question, because I'll go in order. I almost want to skip this one and come back to it, but I'll hit it. And I don't know how up to HIPAA you are, but my doctor was told we can have the patient sign a do not bill insurance form for services that are covered or would be a write-off by insurance. That way we can recoup the payment. Is this legal? What that form that they're talking about is, anonymous attendee, is a HIPAA disclosure restriction. And that is something that the omnibus rule gave people the ability to do under HIPAA, was to specifically restrict the disclosure of a service to their insurance company if for some reason they didn't want their insurance company to know they were getting that procedure. It comes with a few requirements. Number one, the patient must pay your full fee. You cannot give them 1 penny of discount for that form to be valid. Because if you're giving a discount, then they're going to say it was the contractual discount that you used, but you didn't fulfill the terms of the contract. So you're not entitled, if you don't fulfill the terms, you're not entitled to the benefit, and that's the way it works. Number two, you have to have a training process in your HIPAA binder and on your annual HIPAA training on how to handle this disclosure restriction. Because if a patient signs that disclosure restriction and you accidentally send it to the insurance company, you have now what is called a HIPAA breach. And you have to report that to the Office of Civil Rights, depending on how many times you did it, either at the end of the year in your annual reporting, or, if you did it 500 times, then you got to do it immediately. And it's a big thing, and alert the local media, and we won't get into all that, but blah, 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 blah. And number three, because it is a HIPAA disclosure restriction, that patient has the right to rescind that restriction and allow you to submit that claim form at any time, even after the work is done. There was someone in the group, Chelsea, who had heard from some speaker about this fantastic do not bill form because they were tired of the insurance company saying pulp caps were inclusive to the crown, and they wanted to charge. So they had the patient sign a do not bill form, which really is a HIPAA disclosure restriction. And the patient then got the EOB. And this was one of those patients who actually looked at their EOB and called the insurance company and said, hey, why is this on there? I had this, it's on my receipt, but it's not on the EOB. Why is that not there? Effectively undoing the disclosure restriction by telling the insurance company they had it. The insurance company called the office, asked for a copy of the ledger, which they are allowed to do. And the office sent it in and they said, wait, you're using this form to charge patients for things you've contractually already agreed are not chargeable. It may be within the letter of the law, but it's not within the intention of the law allowing you to do that. Now we're going to audit you. And this one, I know they got, into six figures as a refund just for that. So you have to understand the important thing is those patients can rescind that at any time. I've had offices that have called me that said we did a $30,000 full mouth rehab. The patient signed the HIPAA disclosure restriction. We did it. 6 months later, the patient calls and says, hey, I'm rescinding that, send the claim. And we had to do a $19,000 write-off and refund the patient 19 grand.
Wow.
Yes, that's the way that form works, and the patient has that right. So you can use it. I would be very careful about using it to skirt contractual agreements you've already made, and you're a lawyer, and please tell me, because I heard this from, when I was in my late teens and early 20s, I used to play golf with two guys, Dick and Dick, at 6:42 a.m. at Westover Country Club every Saturday and Sunday. And they were both in their 80s. They were both retired and attorneys. And I heard this from them, and it always stuck with me for the past 25, almost 30 years. They would say, you can't sign one contract agreeing to violate a contract you've already signed.
That's right. That's right.
And that's what I see happening all the time when people are using this form. I signed a contract 4 years ago with Delta to agree not to charge patients for irrigation. But now I'm going to use this do not bill contract to charge patients for that. It never sat right with me, I guess it's the moral of the story.
And it just, I mean, based upon your explanation, it just seems like it's a recipe for disaster, both because the patient can rescind it, and then undoubtedly you're going to be in a position where you're needing to refund money, but then you're also putting yourselves into hot water with the insurance company. If you're going to do that, I would just make sure that you're complying with each and every step. And then if there is going to be a rescission by the patient, make sure you get that in writing, and that's included in the patient record. You need to have all of this appropriately documented, and it needs to be included within the patient record.
Right. Yep. So now next question, and this is a good one, and I get this one all the time, so I'm happy you're going to answer this one. Treatment consents, do they make a difference in court? My doctors do not feel that they are necessary.
I could, if I had an opportunity to contact some of my clients to ask whether they thought treatment consents were necessary after they were being scrutinized by the board, and for not having them, I certainly feel confident that they would tell you that they are. You need to have properly completed, properly signed, clearly detailing the treatment that they're consenting to, completed forms, again, that need to be in the patient file. Yes, they make a difference, not just in court, but in any time that treatment is being scrutinized. Undoubtedly, they're going to ask for the signed consent, and it needs to be done, and it needs to be done properly.
Right. Absolutely. Yeah. And I think that's a big thing people miss, is making sure it's by procedure. You shouldn't, right. I mean, everybody has every patient sign a general consent.
Yeah.
But people miss the first part of that word, and it's informed consent.
Exactly right.
And, you should have one for root canals, one for crowns, one for implants, one for this, because really that would avoid the question like popped up earlier today in the group that was, oh, we did an implant on this patient, the implant failed. Now, what do we do? Because it was 6 months ago and their body rejected it. And now do we give the money back? Do we not? Do we this? Do we not? Your informed consent should say, here's all the possible negative things that can happen. Here's all the possible positive things that can happen. I told
Yes.
you your body might reject this. If I go get a brand new knee, my orthopedic surgeon, if my body rejects my knee replacement, is not going to say, oh, I'm so sorry, here's your $48,000 back. It's not going to happen, because I signed the informed consent saying, yeah, my body might reject it. I might die under anesthesia. I could die from an infection. I'll have to take this. I could be allergic to the antibiotics you give me and I might die. And it lists all those positive and negative outcomes, not just I consent to be treated by Dr. Smith.
Right.
Okay?
And you're so right. And it goes beyond just, that, the complications. I've had several board complaints that I've handled for providers where there was bleeding after the procedure, and it was properly documented within the informed consent that bleeding could occur after the procedure, and they were given discharge instructions as to what to do. And because they had the proper informed consent, because they provided them proper discharge instructions, the board, despite what some people may think, the board is not out there to unnecessarily sanction and scrutinize providers, unless appropriate, most of the time. Now, sometimes they get it wrong, and I'm probably one that feels like they get it wrong more than most. But it really does start with that informed consent. If you're telling, it needs to make sure you're identifying the care and the services that they're receiving, and then any complications, adverse reactions that could occur as a result of that procedure to protect you down the road.
Right. Absolutely. All right. So next question, because it seems like the more we talk, the more questions we get, and it's 7:03 and I don't want to keep you from your family. But next question, just real quick one. Is it truly confidential if we call Delta Dental fraud line? After the office I just left, they definitely need to be turned in. I mean, here's what I will tell. I mean, this is what I've been told by insurance company investigators. It can be completely confidential. However, if you call in an anonymous tip,
correct,
and you don't provide all of the information that investigator feels they need to even open an investigation, it will go nowhere. If you miss one tiny insignificant detail, you're anonymous. They can't call you back to ask you that one detail. The entire investigation, even if they have 99% of the info they need, is stopped because they don't have 100. So
yeah. I couldn't have said it better myself.
I mean, at that point, I almost wouldn't want to be anonymous. I understand, like, small town, there's 3 dentists, you just worked at one, they got arrested for fraud, they got audited, they got this, they got that. Well, gee, I wonder who turned me in. You're going to have to testify, blah, 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 blah. I get it, but you know what? Drive 15 miles and get a job somewhere else. That's just...
Yeah, and I think there's, I mean, look, more likely than not, when I get brought into a case where there's some sort of investigation started, we are looking to identify, okay, well, who could have been the source of this triggering, of the audit or the investigation. And more likely than not, we can generally tie it down to 1 or 2 people that it's going to be. So even if you make a confidential tip to the Delta Dental hotline, I think it was, it's challenging to truly stay anonymous and confidential, because more likely than not, they're going to be able to figure out who it was. I think what you need to be focused on, if you are going to make some sort of report, is exactly what Rick said. Make sure that you're providing a thorough account of what you feel like the office was doing improperly, so that it can be investigated properly. Because exactly like Rick said, if you don't provide sufficient information, they're not going to go out of their way to track it down. 1, because you're anonymous, and 2, because they'll just go on to the next one. They receive enough complaints to where they don't have to run down those deficient complaints in order to get to the level where they can start investigating. They have plenty to do. So if you really feel strongly that a prior employer was doing things that necessitated a report, make sure that you're providing enough information that the insurance company or government agency can work with.
Exactly. So next question, is there a legal way to get in-office coverage for a dentist for vacation for a single provider practice? I'm assuming you're asking anonymous number 2 about locum tenens for a dentist who's on vacation. Typically, locum tenens is designed for death or disability. It is not for, oh, I'm going to take a vacation and have somebody cover exams for me for the week and want to still be in network. It goes back to what, Justin had said earlier. It's a day, it's a week, suck it up and deal. It's just the way it is. Is there a legal way? Yeah, 6 months out, start credentialing that associate who's going to work in your office for 1 week during the doctor's vacation, credential them under your TIN, have them as a provider. That way, in the future, if somebody is the dentist out sick, on vacation, leaves early to take his daughter to a soccer game or whatever, and that person's going to cover, they're already credentialed. There's nothing saying a credentialed doctor has to work in your office full time or every Wednesday or they can be a temp, but you have to credential them in advance before doing it. So that's, really that's the legal way. Credential them starting 6 months before your vacation. Next question. This is a good one because we only have a couple left here. Does Medicaid fraud have the harshest penalties?
So I'm not really quite sure what you're saying, harshest penalties, but I can say that, I'll use Ohio as an example. So, whenever I'm representing a provider and they're under investigation, Medicaid, typically when someone's under investigation for Medicaid fraud, that is a state investigation being operated by the state attorney general's office, or even potentially by a county prosecutor's office. It's always my objective in representing that provider to keep things at the state level. The state level, the consequences and the sanctions can oftentimes be less harsh than if we rise it to the federal level. The federal government will investigate Medicaid fraud because, again, it all goes back to federal dollars, and that's how you get to the federal jurisdiction component where they have the authority to conduct the investigation. So when we're ever on the line between potential federal investigation versus state investigation, if we're doing our jobs the right way, we're doing everything we can to keep it at the state level. Between Medicaid fraud and theft, generally speaking, the consequences are relatively the same, and they're all driven typically by dollar amount. What is the dollar amount of the fraud? What was the dollar amount of the theft? That will dictate what the offense level is, and then what are the potential corresponding sanctions relating to that theft level, or offense level.
Right.
I will say, however, that with Medicaid fraud, that's when, and other practice related offenses, that's when if there is a conviction or there is a plea of guilty to those types of offenses, you will find yourselves being excluded from federal and state healthcare provider. You'll be on the excluded list in your state, and you'll be on the excluded list by the Health and Human Services Office of Inspector General. And that effectively makes a healthcare provider radioactive because they can no longer touch any part of a claim that will be submitted. They can't provide any care. They can't work in an office that is submitting a claim for payment by a federal payor. And so in that circumstance, it does make a Medicaid fraud offense harsher than, let's just say, a theft offense, because of the additional collateral consequences that can occur following a conviction for that offense.
Yeah, I'm amazed at how many people don't know about that list of excluded individuals. I was speaking end of last year, so just about a year ago, and it was one of the slides in my presentation was about that list of excluded individuals, and somebody said, "Gee, I wonder." I didn't even know that existed, and they looked themselves up and they were on it.
Wow.
And it was because not they, but the dentist that they worked for was convicted of fraud, and they were brought in to say, yeah, I submitted those claims. He told me to. I did this. He told me to. I did this. He told me to. And, because people don't realize when you look at that, one of it's 99% providers, but there are some who are billing
Absolutely.
employees. And
Absolutely.
they're on there. You get on there, and now, you work at an office that takes TRICARE or the Fed VIP program. They're all federally funded. You can't work there. You can't work
And
there.
that's a great point. There's a lack of knowledge that the exclusion list exists at both a state level and a federal level. And then there's also the misnomer that, well, I'm not a licensed medical professional, so I won't end up on that list. And as you said, you absolutely can.
Yeah, you definitely can. So, all right, next question. This isn't really a legal question, but I'll answer this.
Perfect.
Do you have to give a W-4 and I-9 for temp hygienist for a day? Anything we have to write on claim form for temp hygienists? In 48 states, hygienists are secondary providers. They are not primary providers. They do not go on a claim form. You don't have to write anything on a claim form for a temp hygienist because they are being supervised by the primary provider, that is the dentist in the office that day. As far as the W-4 and I-9, yes, there are states, and this has been a big discussion. The IRS does not classify hygienists and dentists in most cases as independent contractors. They are misclassified when they are independent contractors, whether they work in your office for 4 hours, a working interview for 2 hours, or for 37 years, they are an employee. And there are some states now who on your license renewal, like South Carolina, if you renew your hygiene license in South Carolina, one of the questions is, were you 1099 paid as an independent contractor by any dentist in the course of the past license renewal term? And if yes, please provide their tax ID to us. And that is to trigger an audit, because all employer liability taxes that they didn't pay for you, the state and the Fed are going to go after them to collect those. So there's
a lot of really good guidance from the IRS that's out there that, there are factors that the IRS considers when, an individual should evaluate whether someone is a 1099 contractor versus a W-2 employee. So with a simple Google search, you can find that information. I think someone recently asked, it may not have been in your group, Rick, it may have been in another group, if they could be a W-2 employee and a 1099 contractor from the same employer. Not the question that was asked. The answer is yes, but there have to be separate and distinct services. But the IRS is actually really good at providing a lot of FAQ type guidance that you can find just through the power of the internet.
Right. Yeah, it's pretty simple. So now I'm gonna skip 2. And then the 4 questions we have there are going to be it. If you ask more, I'll write them down and I will put them in the comment section of the repost tomorrow in the posting of the replay for this video. But skipping 2, going down to what we're talking about real quick, is Utah part of the 48 states that are considered employees? They are considered employees as a temp in all 50 states. There's 2 states where hygienists can practice independently, but if they are coming into your office, you are providing their equipment, you are providing them patients, you are providing them and dictating the time they arrive and the time they can leave. In all 50 states federally, they are an employee. So again, check the IRS, but you know, the only time those two states allow hygienists to work independently in an office without a dentist. And as far as having potential temps wanting to temp here that fight us on this, then don't hire them. Find ones who want to do it the right way.
Exactly.
You know, it goes back to the fraud thing. I'm not willing to bring somebody on who off the bat is telling me they want to do things the wrong way. You know, you wouldn't hire an employee as an office manager who walks in the door and in their interviews, when you say, well, what would you say is your greatest ability? What are you best at? Embezzlement. I have gotten away with it every time. You wouldn't hire them. So don't bring in somebody who is telling you off the bat, I'm willing to break the law for money, because that's never a good thing. But okay, do zero charge services have to be submitted? Like redoing a filling? Yes. If you're in network, they do. It's submitted as a zero. If your clearinghouse doesn't let you, print it and mail it. It does affect history. Delta Dental of Arizona in 2021 made national news because they said, we're changing our rule. And if we don't pay for a bite wing, it won't affect the frequency limitation of once every 12 months. That was wonderful. They undid it the next year. So.
And at the risk of stating the obvious, make sure that if you are redoing a filling, you're documenting that in the patient chart as well. Document.
And you have an informed consent saying there's a chance this filling might fail.
Yes.
That's always the good one. All right. So last one, again, we're back to how do temp doctors work. How do they work? As out-of-network providers, unless you have gotten either a locum tenens or gotten them credentialed. That's how they work. It's just, you know, you can't put false information on a claim form, no matter what. You know, I can't tell you how
Well,
many.
you can. I just wouldn't advise you do it.
Yeah, I can't tell you how many clients a year we drop because they say, oh, well, we hired this new associate 3 months ago, but we haven't started the credentialing process. So we submit everything under the owner doctor. And I get on the phone with them and I tell them, no, you can't do that. We're not going to do that. And they say, well, okay, then we'll just, and I actually, the last one that I had to fire, I had to fire a client because he said, well, then we'll just change all the chart notes to my name. I'll sign them all every day, even though, and I'm like, okay, fine. But I'm looking at the column that says Dr. Associate, and he saw all those patients. And now you're saying you're the treating provider. Yep, you got to go. So.
Yeah, when you were asking about what the definition of fraud is, that right there.
that is definitely it. Again, Justin, I want to thank you very much on the replay. I am going to put, if it's okay with you, I'll put your contact information here on the screen. He is also in the Facebook group, and he'll be joining us in Atlantic City next weekend with Andre Sheardan, Teresa Duncan, myself, and Justin will be there on Saturday. So hopefully could see a lot of you there. If you're in the area, great. If not, fly in. It's not a far drive from the airport. We'll see you then. Justin, again, thank you so much. I'm sorry we ran over. That typically tends to happen.
That's okay. I'm sorry for the bandwidth issues.
No, we're
really enjoyed the conversation. Hope we can do it again soon after Atlantic City.
Absolutely. So thank you again. Thank you everybody for being here. I will be sending out the link to the replay tomorrow, probably sometime around lunchtime. Get that sent out to everybody. Please refer it over, and I will put Justin's contact info both on the screen at the end here and in the description of the YouTube video. So thanks again, everybody. Thank you for being here. Have a fantastic night, and I will see you guys tomorrow morning for a Drive Live.
Bye, everyone. Thank you.
Bye-bye.
Thanks, Rick.